In a move that has drawn national attention, the United States Supreme Court recently declined to hear several high-profile appeals, challenging state-level bans on assault weapons. This decision, or rather, this refusal to decide, has left many Americans wondering about the future of gun rights and gun control in the country. By turning away these cases, the court allowed strict laws in Maryland and Rhode Island to remain in effect, at least for now. These states have some of the toughest regulations in the nation, and their laws have become a focal point in the ongoing debate over the Second Amendment. Importantly, the Supreme Court's move wasn't a final word on whether these bans are constitutional. Instead, it was a strategic choice to wait, preserving the current legal landscape and leaving both supporters and opponents of gun control in a state of uncertainty. For now, the status quo holds, but the underlying questions remain unresolved. For gun control advocates, this was a significant, if temporary, victory. They argue that keeping these laws in place helps protect communities from gun violence and mass shootings, and they celebrated the court's decision as a win for public safety and common-sense regulation. On the other hand, gun rights groups were left deeply frustrated. They had hoped the Supreme Court would step in to provide clarity and potentially overturn what they see as unconstitutional restrictions on law-abiding citizens. Many activists expressed disappointment, saying the decision leaves millions in legal limbo. The cases at issue specifically targeted Maryland's 2013 Firearms Safety Act, which bans popular semi-automatic rifles like the AR-15 and imposes strict requirements on gun ownership. Rhode Island's 2022 law, meanwhile, limits the capacity of magazines, aiming to reduce the potential for mass casualties in shootings. Both laws have been hotly contested in lower courts. By refusing to hear these cases, the Supreme Court let lower court rulings upholding the laws stand. This decision has deepened the divide in how gun laws are interpreted and enforced across different states, with some regions upholding strict controls and others favoring broader gun rights. The 6-3 vote, with 3 conservative justices dissenting, highlights the deep internal split within the court itself. This division signals that the national debate over gun rights is far from settled, and that future cases could still reshape the legal landscape. Many legal experts believe the court is waiting for a different case, or perhaps a more fully developed record, before making a landmark decision on gun rights. Until then, the nation remains in suspense, watching and waiting for the next chapter in this ongoing legal and cultural battle. Maryland's Firearms Safety Act was passed after the Sandy Hook tragedy, banning assault-style rifles like the AR-15 and magazines over 10 rounds. Lawmakers argued these weapons, designed for rapid fire, have no place in civilian hands, and that limiting access could reduce mass shooting lethality. Rhode Island followed with a 2022 law banning high-capacity magazines, citing recent mass shootings where such devices enabled devastating attacks. Both states acted as Congress failed to pass similar federal measures, making state legislatures the main battleground for gun regulation. Gun rights groups immediately challenged these laws, claiming they violated core Second Amendment rights. Years of litigation led to the Supreme Court's recent refusal to intervene, leaving the state bans intact for now. The Supreme Court's 2022 Bruen decision marked a turning point in American gun law, fundamentally altering how courts evaluate the constitutionality of firearm regulations. This landmark ruling didn't just tweak existing standards, it established a new framework that has sent shockwaves through the legal system and reignited debates nationwide. Under Bruen, modern firearm regulations must now be consistent with the nation's historical tradition of gun laws. Judges are required to look back in time, examining whether a similar law existed during the founding era, rather than simply weighing contemporary concerns or policy arguments. Previously, courts used a two-step approach, balancing public safety interests against historical precedent. This allowed for more flexibility, letting lawmakers address modern threats while still respecting constitutional rights. But now, if a gun law lacks a clear historical analog from the 18th or 19th centuries, it's presumed unconstitutional. This shift has made it much harder for states to defend new gun regulations in court, especially those targeting specific types of firearms. Gun rights advocates argue that bans on AR-15s and similar rifles fail this historical test. They point out that these firearms are among the most popular in America today, widely owned for lawful purposes such as self-defense, sport shooting, and hunting. Supporters of gun rights also note that there were no founding-era bans on common firearms, and that the Second Amendment was written to protect weapons in common use by law-abiding citizens. Yet, some appellate courts have upheld state bans, reasoning that AR-15s and similar rifles are more like military weapons than the muskets of the 1700s, and therefore not protected by the Second Amendment's original intent. These courts argue that the Constitution does not guarantee access to every type of firearm, especially those designed for battlefield use, and that states have the authority to regulate especially dangerous weapons. This conflicting interpretation has created a deep split among federal courts. Some judges have struck down assault weapon bans as unconstitutional, while others have upheld them, citing public safety and historical context. As a result, Americans face a patchwork of laws and legal uncertainty, with the fate of assault weapon bans varying dramatically depending on where a case is heard. The resulting legal confusion is precisely what many expected the Supreme Court to resolve, but so far, the justices have declined to take up the issue directly, leaving lower courts and the public in limbo. For now, the Bruin Standard remains at the heart of ongoing legal battles over assault weapon bans, shaping arguments and outcomes in courtrooms across the country. Until the Supreme Court steps in to clarify the law, the issue remains unsettled, and the legal landscape fractured, with Americans left waiting for a definitive answer on the future of gun regulation. The Supreme Court's denial came with strong signals from the justices. Justice Clarence Thomas, joined by Alito and Gorsuch, dissented, criticizing lower courts for sidestepping the Bruin Standard by labeling AR-15s as weapons of war. He argued these rifles are in common use and that the court is allowing inconsistent gun laws to persist. Justice Kavanaugh, though voting to deny the appeal, wrote separately to stress that the constitutionality of assault weapon bans is a pressing issue the court must address soon. He called Maryland's ban questionable and noted similar cases like Illinois' are moving through the courts. These statements make clear the Supreme Court is likely to revisit the issue when the right case arrives. Justice Kavanaugh's move to question the bans while voting to deny review reveals the court's strategic patience. By waiting, the court avoids a divisive ruling during an election year, and allows lower courts to further interpret Bruin, building a richer record for future review. Kavanaugh's statement reassures gun rights advocates that the issue isn't forgotten, just postponed. He specifically referenced the ongoing Illinois cases as potential vehicles for a future Supreme Court decision. His message signals to lower courts that their reasoning on assault weapon bans is under scrutiny. This approach could shape how judges handle similar cases, knowing the Supreme Court is watching closely. With the legal battles in Maryland and Rhode Island temporarily sidelined, the national spotlight has now shifted to Illinois, where the next chapter in the fight over assault weapon bans is unfolding. Illinois has become the new epicenter of this contentious debate, drawing attention from legal experts, activists, and lawmakers across the country. Here, both county-level and statewide bans on assault weapons are facing significant legal challenges. The Cook County Blair Holt assault weapons ban, which has been in place for years, is now at the center of a high-stakes legal showdown. Protesters and supporters alike have gathered outside courthouses, underscoring the deep divisions and passionate opinions on both sides of the issue. Gun rights organizations, determined to overturn the ban, have petitioned the Supreme Court after the Seventh Circuit Court of Appeals upheld the law. Their argument is that the ban infringes on constitutional rights, and they hope the nation's highest court will finally weigh in. Meanwhile, Illinois' broader Protect Illinois Communities Act, which prohibits a wide array of semi-automatic firearms and high-capacity magazines, is also under intense legal scrutiny. Legal analysts believe these Illinois cases are particularly strong candidates for Supreme Court review, as they present clear legal questions and have been litigated under the new Bruin standard set by the court. Because the Illinois cases have been argued entirely under this new framework, the outcome could have far-reaching implications. A Supreme Court decision here could set a precedent that shapes the future of assault weapon bans nationwide, providing much-needed clarity on the issue. The legal landscape is rapidly evolving with oral arguments and final decisions still pending. All eyes are now on the Supreme Court, as its next move may depend heavily on how these pivotal Illinois cases progress and are ultimately resolved. The debate over assault weapon bans reflects America's deep divide on guns and the Second Amendment. Gun control advocates argue these bans are common-sense measures to reduce mass shootings, citing the deadly potential of military-style rifles. They believe the government can regulate dangerous weapons to protect public safety, pointing to historical precedents. Gun rights supporters counter that assault weapon is a misleading term for common semi-automatic rifles used for sport, hunting, and self-defense. They argue these bans target law-abiding citizens and violate a fundamental right, insisting the focus should be on criminals, not responsible gun owners. For them, owning popular firearms is central to the Second Amendment's guarantee. The clash is about more than policy. It's about the meaning of constitutional rights in modern America. The Supreme Court's refusal to hear the Maryland and Rhode Island cases hasn't ended the legal battle. It's only delayed it. Conflicting lower court rulings have created a patchwork of gun laws, with some states enforcing bans and others striking them down. This circuit split is exactly the kind of legal confusion the Supreme Court is meant to resolve. With the Cook County case now petitioned, pressure is mounting for the justices to act. As more cases move through the courts, the demand for a clear, nationwide answer will only grow. The court's eventual decision will shape gun regulation in America for generations. Until then, the legality of owning popular firearms remains uncertain, varying dramatically by state.